Appeals. An appeal is a proceeding by which a party seeks from a higher court the review of a judgment or final order of a lower court on the ground that the judgment or final order is against the evidence or the law. Nature of the right to appeal. An appeal is not a constitutional but a statutory right. What may be appealed? An appeal may be taken only from number 1, judgment. Number 2, final order that completely disposes of the case. Number 3, particular matter in the case when declared by the rules to be appealable. That is Section 1, Rule 41. Examples of Section 1, Rule 41, or number 3. Number 1, order of expropriation under Section 4, Rule 67. Number 2, order of partition, that is under Section 2, Rule 67. Number 3, order allowing or disallowing a will, Section 1, letter A of Rule 109. Now, let's see what Rule 41, Section 1 says. Section 1, subject of appeal. An appeal may be taken from a judgment or final order that completely disposes of the case or of a particular matter therein when declared by these rules to be appealable. No appeal may be taken from an order denying a petition for relief or any similar motion seeking relief from judgment, an interlocutory order, an order disallowing or dismissing an appeal, an order denying a motion to set aside a judgment by consent, confession, or compromise on the ground of fraud, mistake, or duress, or any other ground vitiating consent, an order of execution, a judgment or final order for or against one or more of several parties or in separate claims, counterclaims, cross-claims, and third-party complaints, while the main case is pending unless the court allows an appeal therefrom, and an order dismissing an action without prejudice. In any of the foregoing circumstances, the aggrieved party may file an appropriate special civil action as provided in Rule 65. And we can try to memorize Section 1, Rule 41 using mnemonics like the space ID or our body parts. Let's try the body parts. I would use my head for letter A, an order denying a petition for relief or any similar motion seeking relief from judgment. I would use my eyes for letter B, an interlocutory order, and my nose for letter C, an order disallowing or dismissing an appeal, because I might disallow or cover my nose. Letter D, I would use my mouth, close my mouth firm, and think of the 3 C's: consent, confession, or compromise, because letter D says an order denying a motion to set aside a judgment by consent, confession, or compromise on the ground of fraud, mistake, or duress, or any other ground vitiating consent. I would use ears for letter E, an order of execution. So I might want to use my ears and like cover my ears for letter E, an order of execution. I would use neck for letter F, a judgment or final order for or against one or more of several parties or in separate claims, counterclaims, cross-claims, third-party complaints, while the main case is pending unless the court allows an appeal therefrom. And I would use my hands for letter G, an order dismissing an action without prejudice. So if I think of letter G, what's the other part would be my hand maybe holding a mallet. This is another way, but I like the mnemonics made for this space ID. So according to Rule 41, Section 1, the aggrieved party may file an appropriate special civil action as provided in Rule 65. What are appealable? Order of Expropriation, Section 4, Rule 67. Order of Partition, Section 2, Rule 69. Order allowing or disallowing a will, Section 1, letter A, Rule 109. Rule 67, Expropriation. That's Section 4. If the objections to and the defense against the right of the plaintiff to expropriate the property are overruled, or when no party appears to defend as required by this rule, the court may issue an order of expropriation declaring that the plaintiff has a lawful right to take the property sought to be expropriated for the public use or purpose described in the complaint, upon the payment of just compensation, and be determined as of the date of the taking of the property or the filing of the complaint, whichever came first. A final order sustaining the right to expropriate the property may be appealed by any party aggrieved thereby. Such appeal, however, shall not prevent the court from determining the just compensation to be paid. After the rendition of such an order, the plaintiff shall not be permitted to dismiss or discontinue the proceeding except on such terms as the court deems just and equitable. Rule 69, Petition, Section 2. Order for petition and petition by agreement thereunder. If after the trial the court finds that the plaintiff has the right thereto, it shall order the partition of the real estate among all the parties in interests. Thereupon, the parties may, if they are able to agree, make the partition among themselves by proper instruments of conveyance, and the court shall confirm the partition so agreed upon by all the parties, and such partition, together with the order of the court confirming the same, shall be recorded in the registry of deeds or the place in which the property is situated. A final order decreeing partition and accounting may be appealed by any party aggrieved thereby. Rule 109, Appeals in Special Proceedings, Section 1. Orders or judgments from which appeals may be taken. An interested person may appeal in special proceedings from an order or judgment rendered by a court of first instance or a juvenile and domestic relations court, where such order or judgment, letter A, allows or disallows the will. But let's complete the whole section 1. Letter B determines who are the lawful heirs of a deceased person, or the distributive shares of the estate to which such person is entitled. The letter C allows or disallows in whole or in part any claim against the estate of a deceased person, or any claim presented on behalf of the estate in offset to a claim against it. Letter D settles the account of an executor, administrator, trustee, or guardians. Letter E constitutes in proceedings relating to the settlement of the estate of a deceased person or the administration of a trustee or guardian a final determination in the lower court of the rights of the party appealing, except that no appeal shall be allowed from the appointment of a special administrator, and is the final order or a judgment rendered in the case and affects the substantial right of the person appealing, unless it be an order granting or denying a motion for a new trial or for reconsideration. Let's continue. The judgment on foreclosure in Section 2, Rule 68 is appealable within 30 days from notice by filing. Notice of appeal plus RONA. Rule 68, Section 2, judgment on foreclosure for payment or sale. If upon the trial in such action, the court shall find the facts set forth in the complaint to be true, it shall ascertain the amount due to the plaintiff upon the mortgage, debt, or obligation, including interest and other charges as approved by the court, and costs, and shall render judgment for the sum so found due in order that the same be paid to the court or to the judgment obligee within a period of not less than 90 days nor more than 120 days from the entry of judgment, and that in default or such payment the property shall be sold at public auction to satisfy the judgment. The order of confirmation of the foreclosure sale is a final order which may be appealed. Dimalanta versus Ocampo, 20 SCRA 1136. Since foreclosure involves multiple or separate appeals, the appeal shall be taken by filing a NOA and a RONA within 30 days from notice of the order. I'd like to read this case. The court said, an order of confirmation in court foreclosure proceedings is a final order, not merely interlocutory. In appeal, the criterion is not GAD, but reversible error. A party can file a notice of appeal even if there is a pending motion for reconsideration by adverse party. This is under the case Bernardo versus Soriano. However, we have to compare it with JP Latex Technology versus Ballons, Granger Balloons, 581 SCRA, because it was held that a motion for execution pending appeal cannot be granted if there is a pending motion for reconsideration of the judgment. Dual function of appellate court: 1. Review for correctness function, 2. Institutional function, or the progressive development of the law for general application in the judicial system. Classification of appeals. Appeals as a matter of right or ordinary appeal. Rule 40 and 41. Appeal as discretionary or petition for review. Rule 42 to Rule 43. The court may dismiss the appeal on its face if, number 1, patently without merit, number 2, clearly dilatory, and number 3, the issues raised by the petitioner are too unsubstantial to require consideration. Appeal by certiorari, petition for review on certiorari, Rule 45. Modes of appeal. Rule 40, MTC to RTC. Rule 41, appeal from RTC, original jurisdiction. Rule 42, appeal from RTC, appellate. Rule 43, appeal from quasi-judicial bodies. And Rule 45, appeal by certiorari to Supreme Court. Note: a board resolution authorizing the representative to initiate the appeal is not required for the purpose of filing a notice of appeal. This is under United Interior Mangahan Homeowners Association versus De Luna, November 20, 2017. There's also a note here that says, even if the OSH has deputized counsel, he still retains supervision and control of the case. Hence, the period to appeal the decision is reckoned from the service on the OSG, not on the deputized counsel. The abbreviated Section 1, Rule 41, which is are the judgments or orders which are not appealable. We can use space ID. The aggrieved party may file the appropriate special civil action under Rule 65 as for several parties or in separate claims. A judgment or final order for or against one or more several parties or in separate claims, counterclaims, cross-claims, and third-party complaints while the main case is pending unless the court allows an appeal therefrom. P for petition for relief. An order denying a petition for relief or any similar motion seeking relief from judgment. A for appeal. An order disallowing or dismissing an appeal. C for the consent, confession, and compromise. An order denying a motion to set aside a judgment by consent, confession, or compromise on the ground of fraud, mistake, duress, or any other ground vitiating consent. E would be an order of execution. I, interlocutory order, and D, order of dismissal without prejudice. Since the OMB preventive suspension order is interlocutory and thus unappealable, the remedy for an aggrieved party is a 65 petition with the CA pursuant to the doctrine of hierarchy of courts. An appeal from several or separate judgment is not allowed while the main case is still pending unless the court allows an appeal therefrom. Remedies: wait for judgment in a main or entire case and then appeal therefrom. Number 2, file a motion for leave to appeal. If granted, file a NOA and RONA within 30 days from notice of order granting leave. Number 3, file a special civil action for certiorari if GAD. Dismissal with prejudice. Subject to the right of appeal. An order granting a motion to dismiss or an affirmative defense on the ground of pure shall bar the filing of the same. Dismissal without prejudice. An order granting a motion to dismiss or an affirmative defense on a ground other than pure, P-U-R-E, shall not bar the refiling of the same action or claim. Remedy, Rule 65. Where one of the grounds of dismissal was res judicata, even if other grounds are PURE, proper remedy is appeal and not R65. A prior motion for reconsideration of a judgment declaring presumptive death is not a conditioned precedent for a Rule 65 petition. The reason is that the judgment is immediately final and executory per Article 247 of the FC. Judgment declaring presumptive death under Article 41 of the Family Code is immediately final and executory and cannot be appealed. The remedy of the aggrieved party is a special civil action for certiorari under 65. Republic versus Cantor. A prior motion for reconsideration is a judgment declaring presumptive death is not a conditioned precedent for a R65 petition. The reason is that the judgment is immediately final and executory per Article 247 of the Family Code. That's in the case of Republic versus Katubag. Decision in a small claims case shall be immediately final, executory, and unappealable. That is under the 2022 Rep. Fleck or the rules on expedited procedures in the first level courts. Rep. Fleck. Judgment in RSP case may be appealed to RTC under Rule 40, civil cases, and Rule 122 for criminal cases. The RTC judgment on appeal shall be final, executory, and unappealable under Section 2, letter C, Rule 3 of the Rep. Fleck, and should only apply to civil cases, as was the case in the 1991 RSP, which limits the rule only to civil cases. Appeals from RTC in ejectment cases are governed by Rule 70, which provides that judgment in favor of plaintiff is immediately executory without prejudice to appeal. Small claims decision may be assailed by a special civil action for certiorari under Rule 65, as the case of AL ang Network versus Mondihar. Doctrine of finality or immutability of judgment. Once a judgment has become final and executory or final and unappealable, FENFU, it can no longer be modified, even if the modification is to correct an error of fact or law, and whether it be made by the court that rendered it or by the Supreme Court. A judgment or final order becomes final and executory or final and unappealable if no appeal is filed within reglementary period or if an appeal was filed and finally resolved. Section 1, Rule 39. The purpose of the doctrine: to avoid delay in the administration of justice, and B, to put an end to judicial controversies at the risk of occasional errors. Exception. CAS or CASS. Clerical errors or omissions. For C, ambiguity, to clarify an ambiguity in the dispositive portion. S, judgment for support. S, supervening circumstances which render execution unjust and inequitable. When to appeal: an appeal may be taken within 15 days after notice to the appellant of the judgment or final order appealed from. Where a record on appeal is required, the appeal is taken within 30 days after notice of the judgment or final order. Section 2, Rule 40. How to appeal? The appeal is taken by filing a notice of appeal with a court that rendered the judgment or final order appealed from. A motion for extension of time to file a NOA or notice of appeal is not allowed. Let us check Laksamana versus IAC. And this was asked in 2022-2021 bar question. Where a record on appeal is required, the appellant or the appellant shall file a notice of appeal and a record on appeal within 30 days after notice of the judgment or final order. Section 3, Rule 40. Record on appeal, RONA. A record containing the judgment or final order appealed from, copies of related pleadings, papers, and evidence, together with such data as will show the appeal was filed on time. Material Data Rule. The requirement that the RONA must show on its face that the appeal was filed on time is mandatory and jurisdictional. Hence, if not complied with, the appellate court acquires no jurisdiction and the appeal must be dismissed. This is in Araneta versus Madrigal. A motion for extension of time to file a RONA may be granted. The reason is that the record may be voluminous, that it may not be practicable to submit the RONA within the reglementary period. A RONA must be filed with the trial court together with the NOA and must be approved by the trial court. Appeal bonds are no longer required for the taking of an appeal. Record on appeal when required. A record on appeal shall be required only in special proceedings and in other cases of multiple or separate appeals. Section 3 of Rule 40. The rule of thumb to determine if RONA is needed: does the trial court still need to continue proceedings in the case despite the appeal? If the answer is yes, a record and appeal is required since the trial court still needs to hold on to the case records. When is an appeal perfected? It is perfected by the following: appeal by notice of appeal, party's appeal by NOA is deemed perfected as to him upon the filing of the NOA in due time. Appeal by Rona. A party's appeal by Rona is deemed perfected as to him with respect to the subject matter thereof upon the approval of the Rona filed in due time. Distinction between taking and perfection of appeal. There is no distinction in so far as appeal by NOA is concerned. However, in appeal by Rona, the taking is different from the perfection, which happens only upon the approval of the trial court of the Rona. When does the trial court lose jurisdiction over an appealed case? Under appeal by NOA, the trial court loses jurisdiction over the case upon the perfection of the appeals filed in due time and the expiration of the time to appeal of the other parties. Appeal by Rona, the trial court loses jurisdiction over the subject matter of the Rona upon the approval of the Rona filed in due time and the expiration of the time to appeal of the other parties. Once the trial court loses jurisdiction over the case, it can no longer act thereon, except to enforce or execute the judgment or final order once it becomes final and executory, to exercise residual jurisdiction under Section 9, Rule 41. It says that residual jurisdiction is the power of the trial court after it has lost its jurisdiction, but prior to the transmittal of the original record or the record on appeal to issue orders for the protection and preservation of the parties' rights which do not involve any matter litigated by the appeal. That is letter P. Approve compromises. That's letter C. Permit appeals of indigent litigants. Letter I. Order execution pending appeal in accordance with Section 2, Rule 39, letter E, and allow withdrawal of the appeal, Section 9, R 41. You have mnemonics P-wise. General rule: no error will be considered by the appellate court unless stated in the assignment of errors closely related to or dependent on an assigned error. Exceptions: error affects subject matter jurisdiction or validity of the judgment. Number 2, plain errors and clerical errors. Note, Section 7, Rule 40. The RTC shall decide the case based on the entire record of the proceedings had in the court of origin and such memoranda as are filed. Trial court can appoint receiver pending appeal when records not yet forwarded to preserve and protect the property in litigation. Hey guys, thank you for your continued support and please bear with me with my review sequence. I will fix my notes and I'll pick it up from here.